Trustee training. Hello, my name is Amanda Francis. I'm one of the partners in the charity team here at Buzzacott. Becoming a trustee of a charity should be enjoyable and rewarding. Charities are such an important part of our society and contribute significantly to our economy, but importantly also to the lives of millions of people in a very diverse number of ways. Trusteeship, however, can be daunting, and rightly so. The responsibilities are onerous. The aim of this seminar is to help you understand those responsibilities and how you can demonstrate them in practice so as to enhance the reputation of your charity and ensure that it can show that its purposes are being achieved effectively and as well as possible. We hope there is something for everyone in this seminar, whether you are new to trusteeship or simply looking for a refresher. We will cover the legal responsibilities of trustees, how those might be demonstrated in practice by following the Charity Governance Code. We will consider the financial governance requirements that need to be understood, as well as diving into a few key areas such as public benefit, risk management and reserves policies in more detail. We hope you find the seminar interesting and helpful. Over the last decade, there have been a number of issues surrounding charities and the charitable sector, and that means that the public is less inclined to look favourably on charities and to give them the benefit of the doubt. Whilst many of these issues have been focused on things like safeguarding or fundraising failures, many would say that what underlies them all is a straightforward failure in governance. So we can all think of some of the issues that have arisen with Kids Company, the RSPCA, Oxfam, Save the Children, the President's Club, and so on, and the list goes on. Because of those issues, and because the charity sector, if you think about the last 20 years, has increased immensely, that means there is intense media scrutiny, not just from the traditional press, but by things like social media, and charities are more and more having to become accountable and answerable. What that means is that the Charity Commission, as the regulator, is shining the spotlight on charity governance even more, and particularly looking at the quality of trusteeship. Charity trustees nowadays need to be able to demonstrate an understanding of their duties. And whether it's right or wrong, charities are expected to demonstrate a higher moral and ethical standard. And that translates back into its trustees. So it's not a matter of just ensuring that you understand your legal compliance duty, but that you are demonstrating that higher moral code. It's also important to remember that there is no such thing as a private charity. All charities are in receipt of public funds, either directly through the receipt of grants or donations or other funding, or indirectly due to the fiscal benefits they have because they are exempt from direct tax provided their income is applied for charitable purposes. All of that highlights the growing need for charities and their trustees to demonstrate good governance and so ensure compliance with laws and relevant legislation, but more to promote a culture where everything is focused on achieving their charity's objectives and vision, today, but also into the future. Now, if you are asked to be a charity trustee, one of your key reference materials will be something called the Essential Trustee. That's a publication produced by the Charity Commission. It's often called CC3, and it sets out everything that you need to know and what you need to do as a trustee, but it does so in a legalistic way. CC3 makes clear that the overriding duty is to advance the purposes of your charity. It goes on to explain that trustees have ultimate responsibility for directing the affairs of the charity, in other words, thinking about its strategic aims, for ensuring that it is solvent, that it is well run, and that it's delivering the charitable outcomes for which it was set up. To act as a trustee, you must be eligible to serve, and you must be confident that you've been appointed properly. Know how long you've been appointed for, and when your appointment ends. That information will be set out in your charity's governing document, and that governing document is something that every trustee should have a copy of, and it should be referred to regularly. If you don't have a copy, or you don't know what it is, then ask your fellow trustees or ask the charity's management team. What CC3 does is it sets out 6 clear duties of trustees, as seen by the Charity Commission. Firstly, to comply with your charity's governing document and other aspects of the law. Secondly, to ensure that your charity is carrying out its purposes for the public benefit. And then it goes on with the need to act in the charity's best interests, to manage the charity's resources responsibly and prudently, to act with reasonable care and skill, and finally to ensure that your charity is accountable. Now what we're going to do is spend a few moments looking at each of those areas and exploring what they entail. And then finally we'll look at what should happen should things go awry. So let's begin with the need to comply with the regulatory landscape. The first aspect of this goes back to that governing document I was talking about. It's about complying with the requirements of that governing document. What that will set out is things like the administrative arrangements for meetings. So, is a meeting quorate? Can you hold meetings virtually or do they have to be in person? And so on. But it will also have other key clauses, setting out, for example, the objects of your charity, why it was set up, what the powers are of the trustees. So do you have the power to invest your charity's money? Do you have the power to take out a loan and secure it against your charity's assets? It will set out how your trustees are appointed, how long they serve for, and very rarely, but importantly, it will have details of how you can remove a trustee from office. One of the final clauses within your governing document will be what we call the dissolution clause, and that will explain what happens to your charity's assets should it cease to exist or stop activity for whatever reason. Now that governing document will be something that was put in place when the charity was initially formed, but it can't just sit there. It's something that is a living document. It will change because society changes, the way we work changes. So therefore it's important that that document is reviewed every 3 to 5 years, simply to ensure really that it's still fit for purpose. Compliance with the regulatory landscape also means remaining true to your charitable purpose and your objects. I just talked then about the way in which society changes. It's important to ensure that what your charity is doing today is what was envisaged when your objects clause was written. If the two are different, we often refer to that as mission drift. It is important that that doesn't happen because it can be dangerous. If you find that your charity is working and carrying out work that is somewhat different to that laid out in your objects clause, you could be accused of acting ultra vires, outside of your objects. And that is one of the few areas where you may be personally liable if a loss occurs and needs to be made good. Every few years, again, look particularly at that objects clause. Make sure that it does match up with what you are doing on a day-to-day basis. If it doesn't, or if you fear that you're starting to drift away from that mission, then it needs to be updated. And the objects clause is one of the clauses that you cannot update without Charity Commission approval. So it is important that you identify if a change is needed. Now, as alongside your governing document, of course, you will have a whole raft of other laws to actually comply with. Firstly, you will have charity law, including things like the need to demonstrate public benefit, to be accountable, but also the laws that relate to fundraising and the laws that relate to things like the disposal of property. Those charity laws will also set out the need to prepare annual reports and accounts, to complete your annual return, and ensure that all of those documents are filed with the regulator by the due date. There will also be a need to comply with the requirements of other laws and regulations. For example, if you're a charitable company, you will have company law to consider. There's a need to think about health and safety legislation. There's the minefield that is employment law. And then there are laws and regulations that are perhaps more important to the charity sector than they are to the commercial sector. Things like GDPR. Charities often have a lot of personal details about beneficiaries and so on. Safeguarding. And the requirements of other regulators such as the Care Quality Commission and Ofsted if they are appropriate. What this means is that you don't have to be an expert in all areas of these laws and regulations. But as a trustee, what you're expected to do is to be aware of when you need to comply with something. And that means asking questions. And I'm often asked, what's one of the key characteristics a trustee needs? And I would say the ability to ask questions. And this is one of the areas where you need to do that. So when you hear by reading or through your work life or something that there is a new law, there's a new regulation, you need to be asking the charity, does this apply to us? Are we doing what we should be doing? Do we need to take advice? And remember always that there is no such thing as a silly question. If you have a question in your mind, you have a duty to yourself to actually ask it. And that aspect of acting with integrity is also important when it comes to avoiding personal conflicts of interest. And also ensuring that you have in place things that you can be confident of operating to prevent the misuse of your charity's funds or assets. Now, we'll talk more about conflict of interest when we talk about the governance code, but essentially what it means is declaring the interests that you may have relating to any item on the agenda at the start of every meeting, and also ensuring that your charity compiles and keeps up to date a register of interests. And one of the easiest way of doing that is to have an annual declaration form where each trustee sets out the organisations that they're associated with, that their immediate family are associated with, so that you've got a list of the organisations that the charity is connected to. I also just want to refer very briefly in this session to public benefit. There are a few key general points that I just want to remind you of. The first is to just say that the public benefit requirement continues to raise complex questions which can be both controversial and, dare I say, political at times. One of the issues we have is that public benefit is not defined in law. There is no statutory definition. That needs to be compared with Scotland, where there is a statutory definition. And just as an aside for the moment, one of the things that could happen at some point is that could cause problems for those charities that operate both in England and Wales, but also north of the border, because there could be a situation where something is deemed to be charitable in England and Wales because it satisfies the public benefit definition here, but actually falls foul of the definition enshrined in Scottish law. That's something that may come, it's for another day. Here, at the moment, what is public benefit is defined by the Charity Commission, and that the Commission make decisions based on existing case law or common law, but accepting that the concept of public benefit may change over time to reflect current social and economic conditions. So, for example, in the 1960s, a gun club could be registered as a charity. That would never happen today. The other thing to just always remember is that public opinion cannot decide what is or is not charitable or for the public benefit. That's for very good reason. It's partly to avoid bias or undue influence from lobbyists and other parts of society. It's important because it ensures that diametrically opposing views can be reflected in causes viewed as charitable. So, for example, a charity that champions animal rights would be deemed to be charitable. But similarly, a charity that carries out research using animals in research laboratories is equally able to be defined as charitable. It isn't a question of whether a purpose is capable of being for the public benefit, but whether there is sufficient evidence to conclude that it will result in public benefit. So, for example, the publication of research into causes of cancer certainly is capable of being for the public benefit, but it will only be for the public benefit and therefore capable of being considered charitable if it is used and results in some sort of action that creates a positive result and is for the public benefit. Now, before I move on from public benefit, just a few words about trustees' reports and the reporting on the charity's work and hence the benefit that is provided. Trustees' reports are of immense importance, but they are often, in my experience, something that possibly doesn't get the forethought that is needed and the planning that is needed to go into it. Within that report each year, the trustees have to report on the benefit that their charity has provided. Now that shouldn't, in my view, be within a separate section of the trustees' report. What the trustees do need to do is simply to confirm that they have had regard to the requirements laid down by the Charity Commission for public benefit. What I think is a far better way of approaching your trustees' report is in the section where you talk about your activities and your achievements, to describe there, by explaining your story, the purposes that the charity is trying to achieve and what it has done during the year to achieve those purposes. So to tell your charity's story using narrative, quotes, photographs and charts. It's one of the areas that the Charity Commission has in recent years been highly critical of. The Commission itself doesn't believe that charities are doing themselves justice. They're not blowing their own trumpet. They're not explaining the difference that they make to people's lives. So again, I would urge you to give time to the trustees' report and think about how you communicate the benefit that your charity brings. So let's now move on to one of the other areas that the Charity Commission require you to give thought to if you're a trustee, and that's acting only in the best interests of your charity. What does that mean? Well, it means, first of all, being aware that you are an independent decision-making body as you sit down as a board of trustees, but that you need to accept collective responsibility. That's all about ensuring you have the ability to have discussion and debate, and the ability to come to a consensus at the end of that debate. What is essential to ensure that is that you have a good chair. What that chair will do is hopefully enable you to make balanced and adequately informed decisions, balancing short and long-term objectives. That adequately informed decisions means that you need to have the information that you require to enable you to weigh things up. But on the other hand, you don't want too much information. You want to be able to look at all of the detail that you've got and come to a decision. And it's for you as a board of trustees to ask for that information, to set out for your management team what they need to provide you for so that you can make that decision. A good board is also a board that engages with key issues, including things like safeguarding matters. So looking at regulators' reports, looking to ensure that there are action plans in place where recommendations have been made, looking at the results of safeguarding audits, and understanding the policies that you have in place to protect your charity. For example, a whistleblowing policy, that your charity has the procedures in place to ensure that at all times it's complying with things like the Mental Capacity Act, and that there are procedures to ensure that your charity's duty of care to employees and beneficiaries is carried out. Safeguarding is just one area that trustees have to engage with. Another would probably be things like cyber security, making sure that you've got the appropriate IT policies in place, whether that be for things like email protocol or whether it be for things like your website and, increasingly important, the use of social media. They're just two policies, but of course your charity will have a whole load of other policies. And one of the things that a board of trustees should be doing is each year having an active discussion about those key policies and procedures, whether they be safeguarding, whistleblowing, complaints, health and safety, employment. It's a very good idea, at least once a year, to have an agenda item whereby you are looking at those key policies as a board. You're reviewing them, making sure you're happy with them, but also making sure that you understand how those policies are actually implemented so that you can be sure that they are in place and operating effectively. So there will be financial policies as well, such as delegated authority limits, reserves, grant-making investments, some of which we're going to cover on this seminar. The other area that is of paramount importance is that you're aware of when there is a potential conflict of interest. Whether that be a conflict of interest, for example, because one of your trustees or more of your trustees are associated with another organisation with which the charity is involved. It could be that your charity has a trading subsidiary. It could be that your charity is negotiating with a funder where, again, one of your trustees has some form of relationship. The key thing when there is a conflict of interest is to remember what to do. And essentially, this is the 3 Ds. The person with the conflict declares that they have that conflict. They then depart from the discussion, so they excuse themselves. And then the way in which that conflict has been managed is documented in the minutes. So, as I said, key conflicts of interest will be where there are personal relationships or where there is a relationship with a trading subsidiary. And in that latter case, you need to ensure that key written documents are in place. So the subsidiary, for example, will probably use the charity's name. So there needs to be a license agreement in place. Similarly, some of the charity's staff may on occasions provide services to that trading company. So there needs to be a resource sharing agreement in place. And the company may well be using the charity's premises. So there should be a license to occupy or some form of lease if necessary. And the final thing to talk about within this particular aspect of trusteeship is to make sure that you've got a good paper, or these days electronic audit trail, so that you've got a record of meeting agendas, that there is a record of all of the papers that were produced in readiness for that meeting, and that you've got a very good set of minutes. And I'll come back to minutes at the end. Now, the next responsibility that you have as trustees is to act with prudence and use the charity's resources responsibly. Now, there are a number of principles here. The first is that the income and property must be applied for purposes set out in the governing document. So act within those objects that we talked about earlier. Secondly, that you always act reasonably and prudently in all matters. Remember, one of your purposes is to safeguard the charity's reputation. Reputations take years to build, but they can be destroyed overnight. So that is an important aspect of your duty. And also that you don't overcommit the charity. It's to think about what can go wrong with your charity. So to carry out a risk management exercise, to identify the big picture risks, what can go wrong, and then to make sure that you've got controls in place, hopefully to mitigate those, and that those controls are operating effectively. And it's about making sure that your charity is solvent, that it's got the financial reserves it needs, it's got the financial ability to take forward its plans and to remain able to pay its debts. Now, the concept of prudence also relates to particular assets. So let's just look at a couple of those. Now, many charities will either have land and buildings that they own or that they lease. There is a need to actually make sure as trustees that you are happy that those premises are obviously secure, that they're properly maintained, that they're properly insured, but also that they are safe places to actually work and to meet. Secondly, there is a need to think about whether the charity has sufficient money and funds to meet its short, medium and long-term objectives. And that's really about whether money should be invested, whether it should be invested because it's not needed until the long term, and hence it can be placed perhaps investments listed on a stock exchange. But it could simply be that the decision is taken to hold funds in bank accounts because you're going to need those funds in the relatively near future. However you invest them, managing those funds and safeguarding them is absolutely crucial. And that's all about having the appropriate internal controls in place, things like delegated authority, segregation of duties, and so on. And then the other asset that you need to think about as trustees is not one that you'll find on your balance sheet, but it's an important asset. It's your staff and your volunteers. Making sure that they all know what they are there to do, that they've got job descriptions, that they know who their line managers are and who to talk to if they've got a problem or they've got an issue. And that, of course, leads on to making sure that you've got a workable whistleblowing process and that you are able to demonstrate that you are complying with that general duty of care. You need as trustees also to be able to demonstrate that you are applying reasonable care and skill. That means bringing with you the experience that you've received from other aspects of your lives. It's that whole aspect of risk management that I was talking about a moment ago. But it's the need also to recognise that however good your trustee board is, It won't always have all of the skills and all of the expertise it needs all of the time. And that means accepting that on occasions you will need to take advice. Now, I know that advice can sometimes be expensive, but often the cost of not taking the advice can be even higher. You do, of course, always owe a duty of care to your beneficiaries, to make sure they are safeguarded, to make sure that they also have an effective whistleblowing process, and that they're able to make their voice heard. Hopefully, in most situations, that will be to give you positive feedback and to say what a wonderful charity it is. But on occasions, they will want to make slightly critical comments. They will want to make a complaint. And you need to ensure that you've got a complaints policy in process, that you as trustees know how it works, and so on. As beneficiaries occasionally having complaints, of course, occasionally something goes more seriously wrong. And that brings in the whole question of whether you should make a serious incident report to the Charity Commission. Now, those reports will most often be lodged with the Charity Commission when there is a risk of loss to the charity, whether that be funds or reputation. So examples of when you need to submit a serious incident report would be when there has been alleged or proven theft or fraud, where there have been serious safeguarding issues, where perhaps you as a charity suspect that money that has perhaps been given to you has come through some form of money laundering or terrorism links, where there are concerns about the charity's solvency going forward. And the final area of your responsibility that's laid out in CC3 is the need to be accountable. So to make sure that you are preparing those meaningful, interesting and good trustees' annual reports, and that attached to those are your annual accounts, that you're filing your annual returns on time, that you've got a good relationship with your professional advisors, whether that be your lawyers, whether it be your auditors, and that where necessary, you're complying and filing those serious incident reports. And at the end of the day, that you are always thinking about the impact on your charity's reputation. So that's the responsibilities laid out in CC3. But what happens if things go wrong? And let's face it, on occasions, they will do. The first thing to think about is, if something's gone wrong, how do we minimise and take steps to reduce any further loss or damage? Do we need to submit a serious incident report? Now, normally, if something has gone wrong and you haven't as trustees acted in any way that could be regarded as negligent or reckless, then any loss that has come about because of that thing going wrong will be made good using the charity's own funds. But what happens if those charities' funds are not sufficient to make good that loss? Well, this is when we start to get into the question of whether your charity is incorporated and you as trustees have limited liability, or whether perhaps it's a charitable trust or an unincorporated association, because the situation is different depending on what type of constitution you have. So if there is a loss and the charity's funds are not sufficient to make good that loss, and you are actually an incorporated charity, so you're a charitable company or a charitable incorporated organisation, then that's where it ends. You have no personal liability, provided you haven't acted recklessly or negligently. The situation is slightly different if you are unincorporated and you're a charitable trust or an unincorporated association, because there potentially you could be required to make good any loss out of your personal resources. And that's why if you are setting up a charity today, the advice you would mostly receive is to do it through either a CIO or a charitable company. Only the most simple of charities these days would be established as a charitable trust. Perhaps if you are a charitable trust, one of the things that you ought to be thinking about at the moment is whether it's still appropriate for your charity to remain as such, or whether you should be considering converting to something like a charitable incorporated organisation to give you as trustees that little bit of added advantage. Everything that we've discussed today is about thinking about your charity, acting in its best interests and reducing the risk to your charity. So let me just recap on those things that you need to be able to demonstrate if you are trustees. First of all, demonstrating that you understand your responsibilities. Secondly, demonstrating that you know what is in your governing document and that you are complying with it. Thirdly, ensuring that you have sound induction procedures. So your new trustees not only understand their legal responsibilities, but importantly, they also understand the charity that they're going to take responsibility for, what it does, how it operates, what its vision actually is. It's about dealing with conflicts of interest, those 3 Ds, and maintaining a register of interest so that everybody knows when there is a potential conflict. Making decisions properly, being properly informed and having the information you need to come to a conclusion. Being prepared to challenge assumptions and asking those key questions of yourselves, but also of charities management. And being slightly sceptical, helping you to just dig a little bit deeper and to make sure that you're entirely happy. Being a trustee means devoting time and having regular meetings. Anybody who tells you that actually being a charity trustee means just turning up for a couple of hours 4 times a year doesn't really understand what trusteeship is about these days. It's about having regular meetings, but having time to look at the papers and having communication with one another and with management between meetings. It's about knowing when you need to take advice, making sure that you've got effective management and internal controls and that your charity is complying with all the laws and regulations that it has to comply with. About ensuring that your charity has the resources needed, whether they be financial resources, whether they be people resources, to meet its contractual obligations. And then finally, it's about 2 things. It's about retaining key documents. And whatever GDPR says, I think there are 2 or 3 documents that you should keep forever, obviously under the appropriate circumstances. But the documents that I would list as you needing to keep are things like your insurance policies, so that you can always prove that you are adequately insured should an issue arise in the future. The second document that I think you should keep forever is the actual signed copy of your annual accounts, and then minutes. Now with minutes, they need to be good minutes if they're going to be effective. They shouldn't be a verbatim record of everything that was discussed at the meeting, but nor should they just be a list of action points. The good test for minutes is to go back to minutes that you took for a meeting that was held a year, 2 years ago, and to read them. And then to ask yourself the question, do these minutes make it clear to me what was discussed, what was actually decided, and why it was decided? What was the justification for the decision we came to? And then the final document that you may need to keep forever is anything relating to safeguarding paperwork or things that can prove at a future date that you were taking safeguarding seriously and you had the right controls and processes in place. And so to conclude, trusteeship should be enjoyable and rewarding. But to be so, it is imperative that trustees understand and demonstrate that they really appreciate what their responsibilities are. I hope that this session has provided you with a summary of what those duties are. Thank you.